Good afternoon, everybody. I'm Liesel de Tooy from the Worcester Local Offices of Legal Aid. I think that we will allow another 5 minutes for delegates still to join the webinar. So we will start 5 minutes past 2 if that is fine with everybody. Thank you. Good afternoon and a warm welcome to everybody again. If it's in order with everybody, I think we can resume with the webinar. A warm welcome to all our valued stakeholders, especially in the criminal justice system, including our CSOs and our colleagues from Legal Aid South Africa. Today we are presenting another webinar in a series of webinars brought to you by Pillar 3 of the NSP on GBV and Femicide Collaborative. If you have attended previous webinars, you would be aware that these webinars seeks to focus on the new developments in terms of the 3 new laws on GBV, but further, these webinars focuses and seeks to empower citizens, the public, on how to access certain services and what services are available, and even what increased level of services are available through the various role players. Now, today we are focusing on legal aid services and especially civil legal aid services. So in terms of Legal Aid South Africa, the services that we are focusing on are will be presented or will be given to you through the presentation. Now this presentation will inform you as to what services are available, how to access these services should you need to access these services, and where to go to should you access civil legal aid services. And obviously also this webinar will also inform you as to what type of services will be available through Legal Aid South Africa. Now today's presenter is Aisha Ghani. She is the head of office of our Germiston Legal Aid local office. She has been with the organization for many years. She has a vast experience into the various types of services that is delivered by Legal Aid South Africa. I really hope that you will find this webinar informative, and if there is no further questions, I would like to, and it's an honor and a privilege for me to tell Aisha Ghani that she may proceed with today's presentation. Aisha, if you are ready, you may proceed. Just for house rules, should you have any questions, you may write your comment in a comment box and or raise your hand. And I think if it's in order with Aisha, then after presentation, we can then attend to all the questions and answering thereof. Thank you very much. Aisha, up to you.
Thank you, Liesl. I hope I'm audible enough.
Yes, you are. Thank you.
Thank you so much. Thank you, Liesl and team, for the opportunity that has been provided to me to present one of these series of webinars. I'm really excited about the topic and also to share whatever knowledge I have at my disposal with the team that's joined us today. I have already been introduced by Liesl, and thank you for that. I am the head of the legal aid in Germiston, of the Legal Aid South Africa's local office on the east of Johannesburg, and an attorney by profession. However, I want to start my introduction with something I read many years ago that has had an impact on me personally whilst working with underprivileged and marginalized clients that face various forms of victimization, abuse, and trauma in their daily lives, which then turns out to be litigious matters in various courts. Now, I'm going to open the webinar with these profound words. by upholding the laws that promote the protection of gender-based violence, of victims' rights, we try and protect the fiber of the very democracy that has shaped and given feet to the laws that allow us to practice in this country. I'm going to say unquote, but as I said, I've read it a long time ago and I don't know who the author is, so forgive me for that. It is for this reason that the protection of gender-based violence is legislated very vigorously, and not only in the civil sections of our laws, but also in the criminal sections. Today's webinar is going to concentrate on civil legal aid as far as GBV matters are concerned, and they span across various courts, from your matrimonial matters to your domestic violence and maintenance, children's courts, etc. Now, Legal Aid South Africa has a mandate, a legislative mandate, if I may put it that way, in terms of the Legal Aid South Africa Act 39 of 2014. So what it says in section 3 is that the objects of Legal Aid South Africa are to do various things. Number one, render or make available legal aid and legal advice to those who qualify and are deserving. 2, to provide legal representation to these persons at state expense. And 3, to provide education and information concerning legal rights and obligations as envisaged in the Constitution and the Act. What we must not forget the legislative mandate is to provide quality legal services, not just legal services. You may move on to the slide, the next slide. Thank you. Now, if we can just go back a bit. The Constitution, Act 108 of 1996, in section 28, subsection 1, states that every child has the right to legal representation assigned to the child at the state expense in civil proceedings where the child is affected and if substantial injustice would otherwise result. Section 34 further guarantees the right to have a dispute resolved by the application of law decided by fair public hearing before court, or where appropriate, an independent or impartial tribunal or any other forum. So if one looks at the mandate of Legal Aid South Africa, we realize that we are here to analyze the facts presented to us in legal matters, the defenses that may possibly be used, and the history of any dispute by applying the law applicable to the facts and then take the matter further. If we look at the national footprint that is on the slide now, we have 128 offices across the country. All the little red dots are marked as our local offices, and the blue dots are satellite offices. So access to legal aid by the marginalized and qualifying clients is made very easy due to the footprint in the country. I'm going to move on to qualifying for legal aid in civil matters. It's often the first question asked, who qualifies and how do they qualify? And what is your cut-off line? I've heard that a lot of times. So we use a means test, which is part of our legal aid application form, and it is completed at the time that an applicant applies for legal aid. The means test is regulated and provides for a test to be applied, which is a mathematical test. And as from April 2022, the rebate applied for single applicant income earner is 7,700 rands. To a household, we take into account the combined income. For instance, if there is somebody that has applied for legal aid and still lives in a common home with other family members, then we take into account the combined income, and the cutoff there is 8,400. However, these regulations also determine that we must take into account both movable and immovable assets when we determine the affordability of an applicant for private counsel versus legal aid SA services. So let me explain this as such. If we look at assets like immovable property, movables such as motor vehicles, investments held at banks or investment institutions, and other interests. For example, if a person is a trustee of a trust or has a benefit in a trust, we then calculate
Aisha, are you there? Okay, it seems like she's there. We could just going to give her a few minutes.
Sorry,
thank you.
Yeah, I'm back. I'm back. Sorry, I had a short disconnection. Apologies for that. Can you hear me?
Yes, thank you, Aisha.
Thank you, Lizzle. Let me just go back to movable assets. So I was still explaining the rebate for movable assets being 141,900. And then immovable assets such as properties, apartments, freestanding houses, even if the person has more than one house, we take all that into consideration, rental income, and the rebate is 665,800. A rebate is what is deducted from your income to determine whether you qualify for legal aid. At the end of the means test, you must be left with a minus balance to qualify for legal aid. But say, for instance, you exceed the means test and we've applied all the rebates applicable, you still have a positive balance and not a negative balance. You still have the right to appeal the decision of a local office where legal aid was refused. Your decision will be accompanied by a motivation of your circumstances, as well as this motivation will be forwarded to either the provincial executive of the particular province wherein you've applied, and then to the national executive. The key aspect that I want to bring home is that the regulations provides that when there is litigation between spouses, the income of the other spouse is not taken into account. So that's a very key point. In these type of matters, we are talking mainly matrimonial matters, divorces, maintenance applications, Rule 43s, Rule 34s, etc. Even when you exceed the means test, in these type of scenarios where there's litigation between spouses, you still can appeal, and a decision maker at a higher level, like I've alluded to before, could still find that you are deserving of legal aid due to your exceptional circumstances. When applying for legal aid, it is paramount that the applicant is forthright and sincere and declares all incomes received, including maintenance for minor children. When you appeal against any refusal, you should make sure that you write down a factual motivation that explains your circumstances, even though you exceeded the means test. In other words, you will be making a case out for yourself that you cannot afford the cost of legal counsel or legal attorney's representation due to your set of circumstances which are compelling and deserving of legal aid assistance. If you sell yourself short in this motivation, you stand the chance of being refused legal aid. So don't leave any important parts out of your personal circumstances financially. That is just my advice to applicants. With your permission, Liesel, may I proceed? Or do we want to stop and take questions at this stage?
At this stage, I don't see any questions. I just see people sending the email addresses. I don't know why. Some people can see the slides and some not, but I'm trying to send for all of those who's requesting the slides, I am emailing it to you.
Thank you then. I will then proceed with your permission, Liesel. We're talking now Thank you. I'm going to proceed and speak about a term we call prospects of success. It's also known as merit assessments. In the private sector, it's called analysis of client's case. And in some of our quality documents, we call it good and bad facts. It's all one and the same. So it's important to note that in addition to applying for legal aid and qualifying for legal aid, the Legal Aid South Africa regulations provides that legal aid may be granted for civil matters where there are prospects of success in the matter, where there are prospects of enforcement, and where it has resources. So it's a three-legged approach. The prospects of success and enforcement is determined by conducting a merit assessment, which we look at the law, we look at the facts that are presented to us by our client in the particular matter, and what we can and cannot achieve versus what client wants. We can therefore only proceed with a matter when we have determined that there are prospects of success. I want to add some information here before I move on to the next slide. I want to explain to our attendees that prospects of success simply means where facts are analyzed to assess if client has a legal claim, or vice versa, if client has the defense against a legal claim. Now, how do we do this? It's simple. We only look at the important facts. Those are assessed, but the history of the dispute is exceptionally important. It is summarized so that it gives us background knowledge. And then we look at the laws applicable to the facts, and we match those together in order to come to a close to 99 to 100% accurate merit report or legal opinion. We can now move on. Legal aid services, SA services are available in domestic violence matters, in divorce matters, and in children's matters. Now, I'm going to start with the domestic violence matters. So the regulations state that in a maintenance case, in terms of the Maintenance Act 1998, a domestic violence case in terms of the Domestic Violence Act of 1998, or a matter in terms of the Protection from Harassment Act are all covered in terms of the above regulation. Legal aid may grant legal aid to an applicant for an initial consultation to advise, and the advice is primarily on the ground facts that are presented by the client, on their rights, what they can and cannot do, their procedure to follow in such a matter, and the prospects of success at face value. And I say at face value because a subsequent consultation, once legal aid merit report has been conducted, would be much more in-depth and strategic. In other words, a legal strategy will be explained to the client on how the matter going forward is anticipated to be tackled. May I proceed, Liesel? Do we have
Yes,
any
thank you.
questions at this point?
No, at this point, no questions. I am monitoring the comments.
Thank you. Now, continued to the to what I've earlier said. Legal aid may be granted for legal representation in a court hearing for matters referred to in our sub-regulation 1. Now, if in the opinion of Legal Aid South Africa, the legal aid applicant's claim or defense, remember I spoke about assessing both the claim and the defense. If either or has good prospects of success, and on the other side, the opposing party is represented by legal practitioner or is a legal practitioner, then legal aid may be granted. So it's a two-leg approach. So one, there should be prospects of success, and the opposing party is represented or is a legal or is a legal practitioner himself. However, subsection 2, not subsection 2, but number 2 extends the legal assistance to applicants who are aged 60 years or disabled. And further, there's a further inclusion recently to vulnerable groups in terms of the Domestic Violence Amendment Act. So that's quite a wide bandwidth and a very simple and non-pragmatic approach to be represented in these courts. If I proceed, in divorce matters, often there are questions. Who qualifies? Who gets legal aid in a divorce matter or in a matrimonial dispute? Legal aid may grant legal aid, services, and representation in a divorce matter where, firstly, there are allegations of domestic abuse, or there is a child, or there is a child that's disabled or intellectually or mentally challenged child, or there's immovable property, which is part of the joint estate, which is part of the dispute, where there's no pension interest or no substantial benefit in the joint estate. Sorry, I meant to say where there is substantial benefit of the joint estate. So just going to go through these again. Where there's any allegation, not proof, allegation of domestic abuse, where there's a child or children, including disabled or intellectually challenged children, immovable property as part of the joint estate, no pension interest, and any other substantial benefit to the joint estate. However, post-divorce assistance is usually applications by applicants that approach Legal Aid South Africa to enforce divorce court orders, or they come with disputes regarding care and contact of minor children. In these cases, we cannot grant legal aid where the family advocate report does not support the client's instruction. The reason for this is that every divorce matter, before it is finalized, encompasses a comprehensive family advocate's investigation and report, and whether the matter is disputed or undisputed, which we call settled matters, those reports are ventilated in trial or via settlement negotiations. Moving on further to our regulations again, insofar as children's matters are concerned, the Constitution guarantees the right to legal aid for children, and therefore legal aid has always been available for children's rights. The Legal Aid South Africa regulation in respect of children provides that legal aid may be granted to a child for legal representation, to intervene in divorce matters, care or maintenance proceedings between the parents of the child, if it is necessary to protect the best interests of the child, or if substantial injustice would otherwise occur. So ordinarily we would not step in, but if it means that we've got to step in as the legal representatives of a minor child to protect that child in a battle between the two adult litigants, then legal aid would step into the matter. Further, legal aid may also be granted to a child in a domestic violence and harassment matter in those courts. Now, often when we go out on outreach programs and to our judicial officers and other stakeholders, we are asked this question: what happens to children that are not South African? Now, legal aid regulations are clear with regards to that. Legal aid may be granted to an unaccompanied foreign child as contemplated in the Refugee Act, but only if it is to protect the best interests of the child and if substantial injustice would occur had this child not be represented. The question comes again, and I'm sure the floor might have this question. If there's more questions, I'll answer them later, but I want to substantiate by stating that in these type of matters, an assessment is done very objectively, looking at the court file or any documents at our disposal that have been referred to us by the Children's Court or any other party of interest in such matter. That brings me to an end of this presentation. However, I would just like to add a few things that's not on the presentation before I open the floor to comments and questions. In the earlier slides, we spoke about post-divorce assistance. In other words, there's already a decree of divorce and parties want to vary, or there's a dispute now about maintenance, or there's a dispute about the sharing of the property in terms of a settlement agreement. Post-divorce type of applications are also falling within the same ambit as the regulations dealing with divorces. So some of the common ones that we see are applications for variations of divorce decrees, where there are typing errors on the decree of divorce, and when one or the other litigant tries to pursue the payout from a pension fund administrator on the court order, they have difficulty, and often we then apply for a variation, which is merely an administrative application. The others that we see often are applications for receivers and liquidators, where there is no agreement to divide the assets post the court order, and merely a blanket order for division of the joint estate. And a third, but not seen, not seen so often, is a review of a order based on irregularities. So that was what I wanted to add, as well as say thank you very much for providing me with this opportunity.
Aisha, we have the first question. I would read out the question. It is from Fatima, and she says, what are the prerequisites in getting representation for a child? That's number one. That's the first part of her question. And yeah, is it possible to obtain
if I may
representation?
can I just repeat the question? What are the prerequisites in getting revisitation?
No, representation for a child.
Representation for a child.
Yes.
Yeah, I will answer that.
And
so
then
let me get all the questions.
And then the second question again from Fatima is that, does legal aid assist with appeals in divorce and family law matters? And again, what would be the prerequisites? I think that is the questions of Fatima. So maybe we must first deal with Fatima's questions, and then we can go on to another question from another person. I don't know if you would prefer that.
Yes, I will deal with Fatima first. So the second question is, does legal aid assist with appeals in
family law matters and divorce matters?
Okay, so let me answer the first question, Fatima. Thank you for your question. Your question was, what are the prerequisites in getting representation for a child? So I did cover that in my presentation. However, I'm just going to explain it to you again and a bit simpler. So often a child is stuck between litigious parties, and they are often related to the child. So how we work with children is that these matters are often litigated out of the children's court, and in some cases, if it's not the lower courts, it would be the high court, and the family advocate would be involved, where the family advocate would investigate and prepare a comprehensive report entailing all the facts and legalities that face the matter. In terms of the Children's Act, the legal aid is appointed to represent children in those type of disputes. So the prerequisite would be a referral from a court to legal aid, and And often, you know, the means test would be done and would be signed off by a social worker or a family advocate. I hope I've answered your question, unless it goes deeper.
Thank you, Aisha. And then we can proceed with the question of Paul. Paul asks, what are the timelines for the application to be processed and feedback be provided to the applicant? I presume it's for any legal aid application, civil legal aid application now. What are the timelines for the application to be processed and feedback to be provided to the applicant?
Okay. That one, I'm going to also give you a very, very easily understandable answer. So applications are done at various local offices, and an applicant usually sits with a paralegal who completes all the necessary application forms and undertakes the means test. The application is captured within 24 to 48 hours. And how do you know what happened to your application? The application then goes through a process on our internal systems of being evaluated, so that the evaluation is actually a quality control procedure, so that we don't miss important information on your application. And it is then allocated after evaluating. It is then allocated to a lawyer, who we call practitioners, or whether it's in the civil section or in the criminal section. And then you receive an SMS to inform you that your application for legal aid is successful. However, our paralegals also contact applicants where there are information that was missing and the application was placed on hold, for you to bring that information promptly. So our systems are very electronic, and our turnaround times are monitored strictly. So your question was twofold. It was, what were the timelines, and how soon, I think you asked, how soon would you get an appointment with an attorney? Or was that not the question?
The question was, how soon will the applicant know? So I think that
Yes.
is also, yeah.
Yeah, so as soon as your application is approved, you will hear from Legal Aid South Africa. So you will receive an automated SMS. And thereafter, the practitioner who has been handed the file will contact the applicant to set up the first consultation. That would depend, and I cannot give you a time frame, but it depends on the practitioner's diary, as they all run their own diaries, and his availability. But depending on the type of matter, the matters would be dealt with in accordance with sequences of urgency. So you would hear from the attorney in that week or so, and a suitable arrangement would then be made that suits both the client and the attorney.
Thank you, Aisha. And then another two-folded question is from Mpalu. The question is, are you able to assist with variation applications in a divorce matter where the pension scheme is not correctly cited? That's the one question. And then the other question from Mpalu is, do you assist with the completion of divorce papers where the plaintiff is not represented and also a lay person or not able to write. So the first question is, do we assist in variation applications where the pension fund is not correctly cited? And the second question is, do we assist laypersons who cannot write also in completion of divorce papers?
Okay, thank you so much for those questions. Right, I'm going to answer the first one. Are you able to assist with variation applications where the pension scheme has not been correctly cited on the decree of divorce? Yes, we do take those applications subject to all the regulations and subject to the application forms and application procedures being complied with, subject to the means test being complied with. However, we have had a lot of success in variation applications where there was 1 digit or 2 digits typed incorrectly by the typists that were tending to the decree of divorce. And in some instances, we had to approach the High Court for an amendment. And in other instances, we directly approached the regional court presiding officer and requested to note issue us with an amended decree of divorce. So both those approaches are very possible and they have been done. And it's not a tardy and long process. It is doable and quite efficient. Second question, where the plaintiff is not represented. In other words, it's the plaintiff's doing the divorce, him or herself, and has served the defendant with the particulars of claim and the summons commencing action. The defendant, being a layperson, is unable to reply or enter his appearance to defend and doesn't know what to do. So Legal Aid South Africa local office teams usually do not say to such applicants, don't come to us, because not everybody knows what to do. So if you come and apply for legal aid when you are served by an unrepresented litigant, our paralegals are very equipped to assist you in completing the do-it-yourself notice to defend in order to save you from falling out of time. And then from there, they would usher you to the registrar of the divorce court or the clerk at a divorce court, meaning magistrates court, who have officials that will assist the unrepresented party to complete the plea to the plaintiff's, the defendant's plea and counterclaim on standard forms that the courts have at their disposal. However, we do appreciate as legal aid that people need advice and they need guidance, and our paralegal capacity is available to assist with regards to that.
Thank you, Aisha. And then there's another question. It's also a two-folded question. The question is from Sharnay. In her question, she asks, in a post-divorce matter, what happens if both the husband and wife need legal aid? Does legal aid then come on record for both parties? That's the first question of Sharnay. I don't know if you want to first deal with the first question, Aisha.
You can give me both.
Okay, then the second question is, in civil matters, You said that one leg of the inquiry for legal aid to come on record is that there should be a reasonable prospects of success. Who determines whether there are reasonable prospects of success? And when there are so many variables that could swing the that could swing the pendulum of reasonable prospects of variables that could swing the pendulum of reasonable prospect of success. And if the client has to determine whether there are reasonable prospects of success, if the client has to determine whether, it seems like there's a repeat. If the client has to determine whether there are reasonable prospects of success, is that not unfair on a person not familiar with the law? So I think the question is, number one, is who determines reasonable prospects of success? I think there's a bit of confusion. It seems like Shanae thinks that the client must determine reasonable prospects of success. And so, yeah, the main question is, in fact, who determines a reasonable prospect of success?
Okay. Let me answer the first question of Shanae, which is, if a matter is opposed, what if both husband and wife need legal aid? Right. This is not it's not you know, a scenario that we faced with often, but we do have them from time to time. And so if we are already representing the plaintiff in a divorce matter and the defendant then approaches the Legal Aid South Africa for representation due to limited means or other reasons. And if it is, sometimes it's in the same jurisdiction, sometimes it's in a different geographical jurisdiction. So if this is the scenario, then the same procedure applies. We would assess the matter, and then we would make an informed decision with regards to assisting the other party that's not represented currently, being the husband, using our other legs of services, which are various options available to us, such as referrals to the law clinics who work close with us. Alternatively, allocating the matter out to other private sector colleagues in the legal industry who are accredited and have partnered with us to do a fair share of accredited legal aid work, whom we call our judicare practitioners. I hope I've answered that question to the best of my ability. The second question, Shanae, that you asked, yeah, it seems like there's two legs to the question. The first, I just want to get the facts correctly. Who assesses the merits of a matter? And if there are what if there are so many variables? I mean, the pendulum swings. Isn't it unfair? Okay. All right. So there's always, when parties that are in litigation, both have their set of facts. And the lose and gain is assessed by a subjective set of facts per litigant. So when you approach the Legal Aid South Africa's attorneys or practitioners, and when we look at the prospects of success, we don't necessarily look at the prospects of success in a matter from the one side. So we look at the prospects of the matter from the papers that clients brings with us to us. In other words, the court process as far as it has proceeded, which will entail a whole lot of summonses, particulars, notices. The matter might also already be at index paginate stage, which is almost setting down for trial. So it's quite a wide question, but what I'm going to say to you is that when we look at merits, we look at the facts, we merge it with the law, we look at the prospects by weighing it on a balance of probabilities, using our expertise and experience, and we then pass our opinion in the form of a finding to either grant or refuse legal aid. I hope I've answered that question.
Thank you, Aisha. And then the question of Matimo. He says, what do I do when I am not happy with the assigned legal aid representative?
Okay, Matimo, you have various options. If you're not satisfied with the legal representative that's assigned to your case, you've got to firstly bring it to his attention, sit down, arrange a consultation, and highlight the issues that you are not satisfied with, and allow the representative to explain the processes, the procedures to you. Should you be able to resolve your dissatisfaction at that stage, which often happens, where client and attorney sit down and discuss their differences. Should you be unsuccessful and not be satisfied at that stage, you may then escalate your concerns to a senior that the practitioner reports to, and then the matter can be investigated from a completely independent perspective, be interviewed by either the supervisory practitioner or principal attorney or head of section or head of office, whoever is in charge of that particular attorney, and they will then sit down with you, listen to you, investigate your complaint at length, and come up with strategies and solutions to rectify if there was something found to be not on board. Alternatively, to equip you with the understanding and the knowledge so that your perception can be eradicated. So I hope that that will help you in taking your matter to the local office where you are being assisted at and discussing it in this fashion.
Thank you, Aisha. And then Fatima says, we didn't answer the second part of her question. Now, the second part of her question was, does legal aid assist with appeals in divorce and family law matters? And if so, what are the prerequisites?
Yes, I see that we missed that question. Does legal aid assist with appeals in divorce matters, family law and divorce matters? I just want to get clarity. Fatima, are you speaking about divorce matters? And when you say family law, then which family law matters?
Fatima, maybe can you just assist us with that? Oh, family law, domestic violence, Aisha.
Okay, so in a domestic violence matter particularly.
It seems like that.
So an appeal. So Fatima, you want to know if we assist with appealing domestic violence orders.
Fatima adds now to say then, as well as divorces in high courts, I think it's correct. It is to appeal in a domestic violence matter. And then she also says then appeal in divorce matters in the high court.
Yes, let me answer that, Liesl. Fatima, my knowledge and my experience tells me that if there is an appeal against a civil judgment, which is obviously falling within your question, then the legal aid SA can assist, but the same procedure follows of assessing the merits in the matter. The second leg, which is the assessment of the means or financials of the applicant. And in this case, because it's an appeal, we would need all the court file of the court a quo's decision, whether it's a domestic violence matter or a divorce matter. So you're talking now appeal. And then we would have to seek permission from the executive for or approval to proceed with the appeal. That's my understanding in terms of the regulations of Legal Aid SA, that this would fall under the ambit of seeking additional approval so that we can then move with the matter. So the answer is actually yes.
Yeah. I see Mpalo says that he didn't hear the answer as to the second question, so I'm just asking me as to the question as to a layperson being assisted by legal aid or the variation of a divorce order when the pension fund was not correctly cited. So I don't know if he can just advise as to which question he didn't hear the answer. But that is as far as questions are concerned. If we
Okay.
can just
Then let me just repeat then for him both answers or both advices.
okay.
So with regards to a layperson that receives a summons in a divorce matter, and the person does not know the do's and don'ts, or he doesn't have a know-how about how to proceed with the matter, I am advising him that he may approach a legal aid office close by to him with the summons commencing action and particulars of claim that was served on him. And the paralegal would then assist him to enter an appearance to defend, to avoid him being out of time to defend the action. Thereafter, the paralegal may refer him to the magistrate's court clerk to assist him further with the do-it-yourself documentation, step by step. And even if the plaintiff is not represented, and he, being the defendant, is a layperson, wants to be represented by Legal Aid South Africa and qualifies for assistance, he may then elect to apply for legal aid assistance. So that was the first scenario. The second scenario that he presented was regarding the pension, the variation application, where the pension scheme, he said scheme, but I think he meant where the court order refers to the pension details incorrectly. I think that's what he meant to say. And for that, I said that we have been successful in amending the court order, and we have done many of those matters. And there are various ways or methods to be applied, but it is doable.
Thank you, Aisha. I just want to see if we have other questions. It seems like we don't have any other questions. I don't. Here comes another one. Sorry, again from Fatima. Please clarify what it is meant by the executive. Are you referring to national level? What is the recourse if you do not receive a response from national level and if there is a rejection? What are the escalation procedures if you're not happy with a decision? So it seems like at national level, if the client is not satisfied with the decision, and obviously it means that legal aid was refused, is there another recourse? And if there is, what is the escalation procedures? And I think after this question of Fatima, we can then proceed with the last part of the presentation.
Sorry, I just had muted myself. Can you hear me now?
Yes, thank you, Aisha.
All right, so when I say executive, I mean it depends on the means test as well as the type of matter. So what was the amount that the applicant failed by? It could start off going on an appeal against refusal of legal aid to a provincial executive, which is the head of a particular province. If it's over a certain limit, it would go to our national operations executive or chief legal executive, CLE. And then I think she also asked about the turnaround time. How long would it take? So the turnaround times are prescribed in our guides and in our procedures. I don't want to just give you turnaround times from thumb-sucked turnaround times, but I think it's 60 to 90 days. I could be wrong on that.
And I also think if the national executive has made a decision, the only recourse is a judicial oversight. I think that is internally, there's no recourse. If one would appeal against a decision of a head of office to the provincial executive, then there is still a recourse. But ultimately, at some stage, your recourse stops and there's no longer an appeal against a decision of the chief legal executive, for instance, or the national operations. And this is in terms of the regulation, and the decision of the legal executive is then final.
That's right. And I also want to just add to Fatima that sometimes applicants fail the means test, and they also are refused legal aid based on the prospects of success on analysis of the facts in the matter. The matter is then appealed and goes to a provincial executive or a national executive. And the decision is then made, and often it's made way before the timelines that are prescribed, for the applicant to nevertheless be assisted based on what we call a contribution scheme. So there's a minimum contribution payable monthly by the legal aid applicant to the local office for us to proceed with your matter. For example, a minimal amount of 300 rands per month. I'm just giving you now thumb-sucked figures. So, you know, there is a lot of effort put into assisting clients that are facing serious litigious matters and are not able to afford private attorneys. Thank you.
Thank you, Aisha. If there is then no further questions, I think we can move to the last part of our presentation. Now, as I've mentioned earlier, this webinar is part of a series of webinars. There are also other webinars that will be taking place within the coming month. And tomorrow there will also be another webinar, and the topic will be vetting of employees at the institution of higher learning. So I also think that would be a very insightful webinar. And I want to thank Aisha. Aisha, you are really one of the heads of offices that we can always approach and say, help us with this. You are really well experienced. You know how we must go about to assist clients. And I know you are very passionate. Civil lawyers, we are very passionate as to assisting clients. But unfortunately, many years ago, my principal told me that, Liesel, you are only as good as the facts of the case of your client. So unfortunately, sometimes how much you want to assist the clients, you are sitting and you must deal with the facts and you must deal with the law. And yes, so legal aid, we really try to fight for our clients, but that is why we say we're always doing a means test. We're taking into account all the relevant factors, the facts of a client's case, the law. We also discuss, we have a vast framework of legal minds, and we discuss matters. So it's not just for legal aid to say, no, sorry, we're not going to assist the client. We really do proper research to ultimately assist and have an impact on clients' lives and a positive impact on clients' lives. So yeah, for Aisha, thank you very much. I was again today reminded as why we need to be passionate as to assisting our vulnerable, our laypersons and the citizens of this country. If there is no further questions, I think we can say that this is the end of the webinar.
Thank you, Liesel, for those very positive words. They also encourage me, as you know, that A lawyer's life has never a dull moment. But I want to take this opportunity of also thanking our audience and our stakeholders for listening to us. And I want to leave you with the words that I live by, which is often lawyers say you as good as your client's case. I beg to differ with that. I believe you are as good as you make your client's case be. When you have opponents, and if you see the smallest loophole or the most minor irregularity, you need to jump into it, because that might be the thing that will assist your client. Also, what's very close to Legal Aid South Africa is client service. And so even though we might not be able to get you the whole house or the whole car, we always strive to get you the best possible settlement or the best possible outcome that can be done. So I'm not just saying this because I work for the organization. I'm saying it because this has been my experience in the years that I've practiced. Thank you very much and have a good afternoon.
Aisha, I'm sorry. I see there's one hand from Dekweni Luwandu. I don't know, Dekweni. Anything else from you?
Thank you so much, ma'am. I wanted to just say whoever wants to be part of tomorrow's webinar, which will be focusing on the vetting of employees in a higher institution of learning, may kindly write his or her own email on that chat box, and then I'll make sure that they do receive the invitation to that. Thank you.
Thank you, Dekweni. So if you've heard Dekweni, if you want to be invited to tomorrow's webinar on the vetting of employees of the institution of higher learning, please just send him your email address on the chat or on the comments box. Thank you very much. This webinar is then completed. Enjoy the rest of your afternoon, sorry.
Thank you. Bye.
Bye, Aisha.